the law currently raises troubling First, Fourth, Fifth, and 10th Amendment concerns. On the First Amendment, courts have long considered video recording to fall within freedom of speech and the press. The right to obtain footage includes the right to record government employees in public space. That ability undergirds one of the primary First Amendment aims, which is to hold government officials accountable. That right is not absolute, but provisions which impact that right cannot, quote, burden substantially more speech than is necessary to further the government's legitimate interests, end quote. The statute on its face violates this test. There are no limits on the government facilities which are covered. There's no requirement for distance from the facility, the direction of travel, or whether the drone is over private property. There's no showing that must be made about specific targets. The provisions could be used to prevent media coverage on matters of great importance to the electorate. It has already occurred. The AG guidelines detailing covered facilities are similarly troubling. To determine whether activities constitute a credible threat, 7 possibilities are offered, some of which, such as the reasonable belief that UAS could harm a person or damage property, it's true of all drones. 6 of the 7 have no nexus to any facility or asset, and any interference in the execution of government activity counts, potentially including lawful protest. Further, to satisfy the requirement that the facility be connected to an authorized mission, the guidelines include any special national security event, which is defined as a designated event that by virtue of its political, economic, social, or religious significance may be the target of terrorism or other criminal activity. All of those are core First Amendment protected activities. The right to petition, moreover, applies to all 3 branches and promotes continual active political engagement. Courts use an experience and logic test to determine whether there is a qualified right of public access to public facilities. The law, however, allows the government to forbid access to all federal facilities and federally owned land without regard to its historical use. On the Fourth and Fifth Amendments, one of the most glaring concerns in the statutory language is that it essentially operates as a general warrant, which is forbidden under the Fourth Amendment. A general warrant is a document issued by an official not based on any evidence of wrongdoing. It lacks particularity in the person or place to be searched or the papers or records to be seized. Unsupported by oath, it's used to find evidence of criminal activity. At the founding, such documents violated the reason of the common law and were thus unreasonable. The current law gives the government the authority to access all communications between the operator and the drone, to seize control of all UAS systems, and to search devices to find evidence of illegal activity. There's no oath, no third party, no probable cause. They act as a general warrant. RF drone detection systems share similarities here with geofence warrants in criminal law, which compel companies to provide location data from users' devices. They also lack particularity. But unlike the drone provisions, geofence warrants involve third-party magistrates, a demonstration of probable cause, and an oath. Even so, circuits are split as to whether they constitute general warrants. For the Fifth Circuit, they do. 124N suffers from the same constitutional defect. Finally, on states' rights, control of real property, including the airspace above land outside of federally owned property, falls in the purview of states. It's reserved to them through the 10th Amendment. There's nothing in the federal provisions which acknowledges state control over adjacent airspace, much less state rights to operate their own UAS over public property. These deficiencies can be addressed to assure the government has the power to protect against UAS while protecting constitutional rights. First, Congress could require a probable cause warrant to target specific drones under the protective measures subject to exigency exceptions as well as the border exception. Second, Congress should institute substantive First Amendment protections. And third, Congress should respect state rights by ensuring that states have the lead for drones under 400 feet and exempting state drones from federal targeting.